Very good. I see Mr. Tinney and Mr. Crawford in the virtual courtroom. Mr. Tinney, we are ready for you. Don't forget to, there you go.
Good afternoon. May it please the court. I'm Don Tinney with Tinney, Meyer, and Picoretto in Clearwater. We represent the appellant, Mr. Stephen Gramay. I'd like to reserve 5 minutes, Your Honor.
Very good, Mr. Tinney.
And Your Honor, this is a single issue appeal concerning procedural due process with regard to a injunction hearing, final hearing on an injunction for stalking, wherein we're alleging that the appellee petitioner was allowed to enter evidence that was both unpled and unnoticed to Mr. Gramay, that evidence was entered over the objection of the appellant. That evidence was also considered by the court and is part of the court's ruling.
Mr. Tinney, as I understand, these are incidents that occurred 3 days before the hearing, and they are incidents that were consistent with the allegations in the petition. Am I right so far?
Yes, Your Honor.
Okay, so these hearings in and of themselves are emergency in nature, are they not? That's why we expedite them, right?
Well, I think they can be, although in this case, there was a previous hearing and there was a supplemental affidavit, which I believe was through no fault of appellee petitioner, but was not served on Mr. Gramay. It was some sort of administrative error.
Well, just stepping back from this case for a moment, this whole statutory scheme is all based on potentially violent behavior between two people, and the legislature put together this statutory framework to address this in an expedited fashion, presumptively because the feeling is these things can't be left to fester because they can turn ugly. Is that a fair, kind of curbstone analysis of this whole thing?
I would say it's fair. However, the legislature also included a requirement of notice in the state.
I'm with you on all that. I get all that. And certainly you're here because you were confronted at this hearing with stuff that wasn't in the petition. And as a good lawyer, you said, hey, I'm entitled to have notice of what it is I got to defend when I get here, right? I mean, that's why you're here, right?
That is correct. Well, I was in the trial.
So I guess my question, Mr. Tinney, given the fact that these incidents occurred 3 days before the hearing, they're consistent with the allegations in the petition, and the fact that these hearings themselves are supposed to be expedited because they are somewhat emergency in nature, because these types of things shouldn't be allowed to fester. What then should be done with these interim activities that occur between a petition and a hearing in this very tight time frame? How should have this been handled? Should have been continued, put off?
That is an option, certainly. However, the case was continued once before under similar circumstances.
Yeah.
But at this point, they're in the hearing during the petitioner's case when these new allegations are first heard.
And of course, Judge Horrocks, who's a very thoughtful trial judge, says, look, these are consistent with what we've already talked about. We can either handle it now, or you guys are going to be back here in another 2 weeks. Isn't that kind of what he said?
Well, that's what he said in answer to the objection.
Yeah,
and for the record, Ms. Smith,
putting aside all the hard rules that we lawyers all live and die by, did Judge Horrocks say something that made kind of sense? Did it strike a sort of a note of, the guy's got a point?
I understand the court's point. At some point, a judge has to be practical, a trial judge. But, Your Honor.
But I mean, these things that occurred 3 days before the hearing, I mean, they weren't just out of the blue things. They were consistent with what was in the petition, just more of the same, were they not?
Well, that's how they were painted. But, Your Honor, I think that argument in and of itself, we have these things, but we can't exclude these other things that are the same, that would allow this unnoticed allegations to come in.
Okay, well, Mr. Tenney, I've done my best to get you to agree with me, and I certainly didn't expect that you would acquiesce, but I think you understand my point, that this judge made a practical decision given this short time frame on these things, and it's really hard to find practical fault with it, but you've got a legal argument that you want to make, so I'm going to get out of your way and let you make it.
Okay. Well, I think the first issue, we talked about notice. The statute requires notice. The third DCA in De Leon Collazo talked about that notice with regard to the domestic violence statute, but the clauses are virtually the same. The only difference, the domestic violence statute says upon which the basis of relief is sought, and the stalking statute says for which relief is sought. So the requirement that allegations of stalking shall include specific facts and circumstances for which relief is sought, that falls under clause.
Delete had several, I think it was 6 separate different kinds of conduct. And I know the court emphasized that to some degree, as compared to here, where the trial judge said quite a bit in his order, but one of the things he seemed to be heavily focused on was the testimony of the employer as to what she observed and witnessed and what she was aware of. So it seems to me that it doesn't seem like the judge gave a lot of emphasis, if any significant emphasis, to the acts that occurred in that 3-day period.
Well, Judge, I would point you to page 175, lines 1 through 6 of the transcript of the trial. First of all, I guess direct you back to where the testimony takes place, and after the testimony, after the objection, and after the court's explanation there on page 43, the practical explanation why he's going to allow it in, the testimony comes in, and then composite 8 is introduced.
Right. Without objection. Or actually, I'm going to take it back. I think there was an objection early on in connection with the testimony, but then when they were actually offered into evidence, there was no objection. The court asked if there was any objection, and the answer was no.
Well, that's consistent, but I think the court has to look at that record together. The court explained why this was coming in. The testimony came in. The photographs associated with that testimony then came in. Those photographs wouldn't have come in by themselves. They would have to be authenticated by the testimony, the allegations that were unnoticed, unpled. So I think the court has to look at those as a whole. And then on page 175, Judge Horrocks, in his decision, relies on those photographs and the testimony associated with those photographs. They're pretty clear. He considers that in his order. So while they may be described as similar or more of the same, they were objected to, they were unnoticed, and then instead of a statement that they did not affect his final order, in fact, he's considering it in his final order. And Judge, for that, I would rely on the line of cases, Collazo, and even this court's case in Stanlick, where trial courts are directed to Peshin. If there's unpled allegations that come in, the court can let them in, but if the court's going to do that, then they must make a statement on the record that they didn't affect their judgment if they're found to be erroneous. I think the record here is pretty complete. The appellee's brief calls them unpled on page 16. Appellee's counsel, the petitioner's counsel at trial, stated they didn't have enough time.
But isn't the whole idea that this is about giving you and your client notice of these new incidents, and in particular, these incidents specifically involved your client. So not only did your client know about them already, your client was involved in them. So this idea that we have to give notice, the idea is that people don't get surprised. So how could you claim surprise if your client was directly involved in the incidents? Your client knew about them.
I'd say that was completely consistent with Patient. The Supreme Court case, 48 Southern 2nd, 726. Patient knew he talked to the officer. He knew he was around the officer. The Supreme Court says because this was unpled allegations, it was a surprise. Your Honor, in this case, the record shows that there was a similar circumstance where the appellee filed a supplemental affidavit. So everybody was put on notice of that. The appellee petitioner knew that was required. And then when we get to the day of the hearing, there's new and unpled allegations that come forth. I think under Peshin, the fact that Mr. Gramay is alleged to have participated in these activities, under Peshin, that doesn't make them not a surprise or not unpled. The procedural due process required here by the statute, by this line of cases, requires that the respondent in these injunction hearings know specifically what allegations they're going to talk about in the hearing, in the final hearing. And that didn't happen in this case, Your Honor. They were a surprise procedurally. They were objected to. And then once the court allowed them in, even judicial economy, practicality, then the court, is directed by Peshin, is pretty clear. A court can do this, but then they must make a statement on the record. And
so, Mr. Tenney, what's the remedy you seek? If we were to rule for you, are you going back for another hearing? Is that what's going to happen?
Yes, Your Honor.
Just going to do it again?
Just going to do it again. And again, Your Honor, I was not trial counsel.
Okay. Okay.
And just back under the Peshin analysis, once this happens and that a court allows in erroneous evidence, that would be the testimony and the composite 8A through C or D. I think it's unclear in the transcript exactly how many there were, but there's certainly several photographs associated with that testimony. Once the court does that, they must make a statement. I let this in, but I didn't consider it. And that's a must under Peshin. And I concede that the analysis doesn't stop there.
Is there any obligation on the part of the respondent to raise that question to the trial court along the lines of what you're arguing now, that, look, Judge, we objected to it. We didn't think it should come in. You ruled it comes in. But if you're going to rely on these unnoticed events, then you have to put on the record that they make no difference in your ruling. Is there any obligation on the petitioner's part to bring that to the attention of the trial court?
That's not how I read Peshin or that line of cases. It's the court must do this. And under this, it's a very narrow set of cases, John. This is a bench trial, not a jury involved. The court allows things in that are erroneous, which under normal circumstances, that's allowed. We have the presumption of disregard in some cases, but this line of cases is pretty clear that presumption goes away once the court lets in this erroneous testimony, evidence. Then it must make a statement on the record. If it does,
and you don't need to repeat the argument. I think we got that point on it. But I do have a question about the cases that you've relied on. each of them seem to have significantly more egregious facts in terms of either what was brought in or the limited amount, what was brought in erroneously, or the very limited nature of the misconduct prior to the hearing. So this case, we've got something like, if I remember, 10 incidents prior to the objected to ones, the 10 that were noticed. And you've got the court focusing on the testimony very specifically of the employer. So is there any ability for us to conclude, even without the statement of the trial court, that this made no difference and would have made no difference had it been excluded as opposed to admitted?
Well, yes, and Peshin requires this court to do an analysis once it's admitted, once it's heard. And the analysis is there a reasonable possibility that the challenge error, the evidence, the photos, affected the final judgment? If there were no mention of it in the final judgment, Your Honor, I think the court, Your Honor, you may have a point there. There was no mention of it. But in this case, not only did it allow it in, he considered it and made it part of his explanation of his final order.
Mr. Tinney, if you want to reserve your time, you're at that point now.
Thank you, Your Honor. I'll reserve.
Very good. Mr. Crawford?
Good afternoon, Your Honors. Andrew Crawford. I'm here on behalf of the appellee in this particular case. Your Honors, this is a situation where the appellant is asking this court to overrule the trial court, remand for a new evidentiary hearing when there is no dispute, at least on the initial appeal, that Mr. Grimet's conduct rose to the level of stalking. It's important to note that prior to this incident, which occurred 3 days prior to the final hearing, Mr. Grimet was told by 2 different judges to leave Ms. Yarrow alone, but nevertheless decided to, 3 days prior to the hearing, do the same conduct for which was alleged specifically in the injunction. Now, as to Mr. Tinney's point, the first issue is A, whether this was raised in any of the pleadings prior to the final hearing. There is no question on page 10 that Ms. Yarrow alleged, page 10 of the record, that Ms. Yarrow alleged that Mr. Grimet was following her, driving by her work, and honking. There is no question that in a supplemental affidavit in 3 separate places, she alleges that Mr. Grimet drives by her work, honking horn, and has done so many times since. I'd also ask the court to take a look at the record at page 40 through 42, where she specifically alleged that Mr. Grimet followed her to a local park. She did everything that she was required to do to comply with the statute in terms of the specific allegations. So as to the first issue, whether or not these were unpled allegations, the focus on the case law that is cited is whether or not the petitioner was placed upon reasonable notice of what would be presented at the final hearing. It's our argument, as detailed in the record, that he was placed on that specific notice. Not only that, he's obviously aware of conduct for which he knows he's not supposed to do when he's told by 2 different judges previously to leave Ms. Yarrow alone. Furthermore, what Mr. Tinney is asking this court to do is not only invited error, I would assert, but he's asking this court to reverse and remand for a new evidentiary hearing when stalking is not even disputed. The evidentiary sufficiency is not even disputed. That's the first prong. The second prong is whether these were material and substantial allegations that were unpled. And Judge Silberman, as you noted, there is the line of cases that relates to unpled allegations within a injunction petition, whether it be dating violence, stalking, or domestic violence, starts with Sanchez versus Marin. Then it goes to De Leon versus Collazo, which Mr. Tinney mentioned. And the last case which focuses on that is Vaught versus Vaught, which is a 4th DCA case. In each one of those cases, the unpled allegations that were brought forth at the final hearing were much more egregious than they were in this particular case. For example, in Sanchez versus Marin, the allegations in the petition itself was a threat to light a fire in a business deal that was gone bad. In that particular case, at the final hearing, not only did the petitioner bring forth a new allegation of an actual fire being set, she brought an additional witness to testify to those acts, which is not what we have here. The second case, which Mr. Tinney touched on, was a domestic violence injunction on De Leon versus Collazo. And that case is distinguishable and is not applicable in this case because that's a domestic violence injunction petition. The petitioner in that particular case didn't allege any act of domestic violence and only did so at the final hearing, which is a significant allegation, which is not what we have here. The last case, which is Vaught versus Vaught, which is a similar type of situation where you have allegations that are brought forth, abuse is brought forth in Vaught versus Vaught, abuse is brought forth at the final hearing, as opposed to being specifically alleged in the petition itself. So not only was Mr. Grimet put on notice, he was specifically on the record, page 10, record 39 through 42. He was also, these allegations were not substantial or material into the judge's ruling below. Third, I would direct the court's attention to Lopez versus Regaldo, which is what I've cited there in my particular brief, which is a very similar factual situation where you have a lot of interaction of the parties in that context, a family law case and some previous injunctions, where the individual is specifically put on notice of what the similar type of allegations are. He goes to the final hearing, new allegedly unpled allegations are raised, and the court in that particular case, the third DCA, said, well, he was really put on notice because he was aware of the allegations from previous court hearings, which is exactly what we have here. Furthermore, in that particular case, the respondent never moved for a continuance, never asked for more time, never took a break in the proceedings, which is exactly what we have here. I understand Mr. Tinney was at trial counsel below, but at no point after the injection was made was a continuance moved for. Ms. Yarrow was subject to extensive cross-examination. The judge was able to hear from both sides, and he made a credibility call and found that, based on the testimony presented, specifically Ms. Yarrow's employer, the third-party witness, that Mr. Grimet was not credible. And now Mr. Tinney is asking the court, and Mr. Grimet is asking the court to reverse and remand for a new evidentiary hearing based on the bad faith conduct of his client, which occurred 3 days prior to the final hearing. I'm asking this court to enter a per curiam affirmance, follow the distinguishable precedent that I have outlined, and I will ask the court to deny and affirm the final judgment of injunction below. And unless there's any more questions, I would ask this court to affirm.
Mr. Crawford, I believe that's the first time you've ever asked for a PCA in your entire professional career, isn't it?
That's exactly right, Your Honor.
Thank you, Mr. Crawford.
Thank you.
Mr. Tinney, you have your rebuttal time.
Your Honor, first with regard to invited error, I know it was mentioned in Appley's brief. There's nothing that happened at trial or in the pleadings that this court should consider invited error in this case. I don't think it applies. With regard to a policy argument, Judge, and if this court rules, as Mr. Crawford has asked, it complicates the law as it's put forth by this line of cases. Now a court must look and say, okay, what is egregious enough or not egregious enough? It's pretty clear now for policy. If it's unpled, unnoticed, it shouldn't come in. And if you do let it in, then you need to follow Peshin. I would take issue with counsel's claim that there was notice. Again, going back to the statute and the cases, it requires specific notice, specific as to what allegations are going to be pled at trial. These were new allegations, never before heard by the appellant. there was no notice of these new allegations via hearing. There's no previous hearing on these allegations. I mean, these allegedly occurred between hearings. If this court grants us a new trial as requested, we're not creating any new policy, not creating any new precedent. It's sticking with the line of cases, both Collazo and under Peshin. Once this type of evidence comes in, trial court's required to do a certain number of things. If they don't, then the appellate court has to analyze it like we've discussed here today. We have to determine if there's a reasonable possibility that the challenge error affected the judgment. I would submit to your honors that when the trial court mentions the evidence as part of what he made his decision on, then there can be no question that this evidence, this erroneously admitted evidence, affected the final judgment. The court says so in its final judgment. Finally, Judge, I think the cases under Peshin, under Collazo, and this court's decision citing Collazo and Peshin in Stanlick, there's a roadmap for a trial court. Don't let this in. If you do, these are the steps you have to take. If you don't take these steps, then this analysis will be done by an appellate court. Judges, I'd ask you to issue an order granting Mr. Gramay a new trial and consistent with our argument.
Very good. Thank you very much, Mr. Tinney and Mr. Crawford. Good to see both of you. That concludes the oral argument portion of our being here. So thank you, and we are adjourned.